Buenas tardes a todos, muchas gracias por su presencia. Esta es nuestra última sesión del semestre del Seminario Permanente de Propiedad Intelectual y en esta ocasión, pido una disculpa de parte del doctor Rafael Pérez Miranda y la maestra Carmen Arteaga, quienes no pudieron asistir, pero muy amablemente han aceptado nuestra invitación para comentar la maestra Luna Mancini y la doctora Laura Correa. Entonces, como han visto en el programa, hoy tenemos como invitado al doctor Luke McDonagh, la City University of London. Esta conferencia entonces la va a dictar él en inglés. Sus diapositivas están en inglés y en español para que puedan ir siguiendo. Y al final nosotros vamos a hacer un pequeño resumen de lo que ha abarcado Luke en su ponencia en español. Después de esto vamos a tratar de hacer comentarios en inglés y en español, en inglés y en español, y ustedes, por supuesto, estarán invitados también a participar y a poner sus preguntas en el idioma que quieran. Nosotros podemos hacer la traducción para el profesor Luke. Luke, nada más para hablar un poquito de él, es de origen irlandés. Él ha hecho su doctorado en la Universidad Queen Mary de Londres y su postdoctorado en la London School of Economics, y actualmente trabaja como senior lecturer en la Universidad City de Londres. Ha dado conferencias en todos lados del mundo. Recientemente estuvo en Hong Kong. Y ahora ha aceptado también nuestra invitación, está haciendo una pequeña estancia aquí en el Instituto. El trabajo que nos va a presentar hoy tiene que ver con una investigación que ha hecho de campo también en el Reino Unido, pero ya veremos cómo se relacionan estos dos sistemas en México y en el Reino Unido, y cuáles son las cosas que tienen que ver en derechos de autor con el copyright. Perdón, pues ahora me voy a permitir hablar en inglés, si me permiten. Thank you very much, Luke, for accepting our invitation to host the last meeting of our seminar. And I've already made a quick introduction about yourself. And please, you can start. I just told them, we are first going to speak the conference in English. We're going to try to make a short summary of it in Spanish, and then we're going to be exchanging for the audience also to participate. Yeah.
Muchas gracias, Ana, por la invitación. Es mi honor hablar inglés. Thank you all for coming. It's really my honor to be here at UNAM. It's really an amazing institution and a great opportunity for me to tell you a little bit about recent research I've been conducting on the topic of theater and copyright law. So, to tell you a little bit about what my study is kind of looking at. Closer, okay. Yeah. I'm looking to examine whether the recognition of the way copyright protects authorship of dramatic works, so plays, works of theater, works of dance, as well as choreography, actually reflects the processes involved in the creativity when these works are created. It's quite clear that copyright has a preference for awarding authorship to a single individual. The reasons for that are mainly practical. It makes more economic sense within the theater industry, within the dance industry, to have one person who has the rights, one person to deal with. It gets more complicated, whether it's music, theater, dance, if you have multiple owners, because you need all of their permission if you want to do an adaptation of the work. So there may be a practical reason behind it, but does it actually make sense when we think about the way in which theater is actually created in the first place? And that's really what I'm trying to look at. I'm also interested in whether cases of copyright infringement happen in theater. There's actually very little case law on theatre and copyright infringement. One reason for this could be that there's generally much less money involved in theatre than, for example, in film or TV or pop music. And court cases are costly, they're expensive. So it could be that it's simply that copyright infringement cases are not worthwhile in an area of creativity where there's not that much income or not that much revenue. And I'm also interested in the moral right of integrity. The idea that the author of the work, the playwright, one of the classic examples of this would be someone like Samuel Beckett, the famous Irish playwright. He left very strict instructions to his estate when he died that, for example, the play Waiting for Godot, his most famous play, should only be played by men. And after he died, his estate actually took a court case in France to prevent an all-female production taking place, and the estate won the case. Later, they took a case in Italy, and actually the estate lost. There, the Italian court said, we will allow the female theatre to put it on because they also have the right to freedom of expression under the European Convention on Human Rights. So, this is a very interesting question as well. I previously published on it. I'm not going to say that much more about that particular issue tonight because we have limited time, and I want to make sure that other people get time to speak and that also that you get time to ask questions. But please, if you do want to ask me any questions later on about this particular issue, I'm very happy to answer them. I'm also not going to focus on things like set design copyrights, the copyright in the set, paintings and so on, furniture that are built for the play. I'm not really going to talk about performers' rights or trademarks. Today I'm really interested in these two issues that I mentioned before. How does the play get authored? And are there cases of copyright infringement, in other words, copying of plays that happen? And how are these resolved if these cases do happen? So as part of my study, because there's so little case law, I thought it was particularly important to actually go out to the field, to talk to people in the world of theatre about what their creative life is like, what their relationship is to the law, and at what point do they actually consider taking legal action? Have they ever been involved in any legal actions? So I tried to do this as broadly as I could within the UK theatre scene. So my university, City University of London, is based in London, but the interviews were with people not just in London, but all over the UK. And one of the interesting things that I found when I did these interviews is that people who work in theatre often perform more than one role. So, for example, I did interview 4 playwrights who are just playwrights and nothing else, 2 producers who are just producers and nothing else, 2 actors who are actors and nothing else. But then the rest of the 20 people I interviewed all had multiple roles, which was fascinating because they could bring different perspectives to different questions. So, for example, there was one participant that I interviewed who was a theatre director, so he was involved in the actual directing of plays, but he'd also worked as an artistic director. So he'd been at the top of a theatre, not necessarily directing individual plays, but deciding the themes that the theatre will explore over the coming year, recruiting directors to direct plays and actors to act in plays based on that. So more of a management role as an artistic director. I also spoke to, you can see all the list of everyone, I'm not going to go through them all, but some of them were quite fascinating. One person, a woman, considered herself to be a writer and a performance artist, because at times she wrote works for other performers, and then at other times she wrote for herself, and she performed one-woman shows for herself. Others also were involved in producing as well as writing and acting. I spoke to one professor of theatre to get his perspective. Someone else worked as a deviser of plays, but also as a choreographer of dance. And some of these writers and actors and producers were very well known, actually quite famous people who you would definitely have heard of. But I can't tell you who they are because I gave the promise of anonymity to all of the the writers, actors, producers, directors. And some of them you would not have heard of. They're much more low-scale actors who are working consistently for the last 10, 20 years, but are not famous, you know. So people working maybe in small theatres in London or Liverpool or Cambridge. Because I wanted to get not just well-known people, very well-off, successful people. I wanted to have a broad approach so that I could really get a spectrum of theatre in the UK. So obviously this is not the final answer to all of these questions, because it's only 20 people and there are many thousands of people who work in theatre, but it gives you a snapshot of what is happening in theatre, and it helps to enrich the answers to these legal questions that I want to ask. So the first area that I want to look at really is authorship. It is important to have some idea of what the legal framework is in the UK for authorship. We have the CDPA 1988. This is the Copyright Designs and Patents Act 1988, and that is the basic law in the UK for copyright. It defines what does dramatic work mean in the UK. What does infringement mean? At what point, if you take influence from someone else's work, do you commit copyright infringement? And also, of course, as I mentioned, things to do with moral rights, those are also covered. So the first important question is, what does this mean, dramatic work? What can be included within the definition? Well, it's not the same as literary work or musical work. These are distinct categories. Dramatic work is defined quite broadly, but there are some very important elements. For example, it can include a work that does not have words. So a work of dance is okay, or a work of mime. Those are all fine. A work of performance art with no words is absolutely acceptable under this definition. One of the key cases we have is Green and Broadcasting Corporation of New Zealand. It's actually a decision of the Privy Council, which is kind of a Commonwealth Supreme Court for countries that are kind of within the British tradition of common law. So this is a New Zealand case, and it established this principle that a dramatic work must be capable of performance. So performance is a key element to a dramatic work. And this has been discussed later on in cases that, for example, have decided that a game of football, even though it can be incredibly dramatic, is not a dramatic work, because it is not a performance. It's actually a sporting event. Well, yeah, of course, sometimes there's theatrics if they're diving or whatever, you know. It can be dramatic, but it's not a dramatic work because it's not scripted. That's probably the best way of looking at it. So a dramatic work has to be capable of performance, which implies an element of script writing. So something like, for example, the Mexican wrestling would be acceptable because there's a script, right? But
there's no script in Mexican wrestling.
Okay,
It's all
Sure, whatever. Anyway, the point is, if there is a script, I don't want to destroy anyone's love of Mexican wrestling, but otherwise the luchadors might try to attack me. But this is the key element, that there has to be a script, it has to be capable of performance, but they don't necessarily have to be words. And under the way the UK law works, if, for example, you're reading a novel by yourself or reading a play by yourself, then it's not a dramatic work. But as soon as you bring it to the stage, as soon as you perform and you read out the lines to somebody, then you're getting to the stage where you are at a dramatic work. Another interesting case, the one at the bottom, it's hard to pronounce, it's Norosian and Arcs, is actually about a case of whether a film could be a dramatic work. And eventually the court said that yes, because a film can be performed in the sense that you can display it in an artistic way. You sometimes do get film art, for example. And so they accepted that a film could be protected not just as a film, but also as a dramatic work. So we have some guidance from the cases, but we don't have a lot of case law on theatre, because, as I said, it's not as lucrative as film, TV, music. So in those areas we have many more cases than in theatre. But we have some guidance that helps us. And this element of performance, scripted, all of those kinds of ideas are very important. So what I want to emphasize from the interviews that I did is, okay, so we know what legally a dramatic work is. It requires a script. It requires something to be written down that can be performed. Or it could be recorded perhaps and then performed again. If it's not written, it could be videoed and then someone else could perform the dance afterwards. There seem to be two ways in which plays get created. I'm talking about new plays now, so obviously if you're doing an old Shakespeare play, it's a different situation. But a brand new play is created in one of two ways. Number one, at established major theatres, so for example, the National Theatre in London, or the Palacio de Bellas Artes in Mexico City. Big theatres will often put on works by famous authors, famous playwrights. So someone like Tom Stoppard or Martin McDonagh, a famous playwright will almost bring the script finished to the theatre. And in that case, it's more clear to see this is an individual work. Someone has worked on this as a script, and then maybe only minor changes will be made during the rehearsals. So that one seems relatively straightforward, but that's not actually the way that all plays get created. For a lot of new plays, especially ones that start at smaller theatres, theatre is devised from maybe just an idea. So the idea might be, let's write a play about revenge, or let's write a play about a love triangle set during the Mexican Revolution 100 years ago, or something like that. So you're beginning with these broad ideas, and over time, through what is called the workshop process, the play begins to be written. So this workshop process is very important in a lot of particularly small-scale theatres, and a lot of new plays get written in this way. So what happens is all of the participants, the writer, the actors, and the director, they get into a room, and they'll work for hours, for days, for weeks at building up this play. The writer will be obviously putting a structure on things as they're devised. The director will obviously be figuring out what works and what doesn't work. Some ideas will be edited out and some will be added in. The actors will be adding some of their own input as well. They could be suggesting lines of dialogue. A lot of creativity happens, and this is a very diverse process. So as I say, sometimes it could start with just an idea. Other times the writer might begin with a script, but the script might change so much during the workshop that by the end it's almost unrecognizable from what it started out as. So the important thing to emphasize here is that everybody involved in this process is collaborating. It's a highly collaborative, creative process. Everybody is giving of themselves to this process. And to be honest, from the conversations, the interviews that I had with these participants, nobody is really thinking about the ownership at this stage, because they're concentrating on the creative aspect, not the financial or economic or copyright aspect. So it is important for theatre that people feel free to give their ideas without necessarily thinking about, oh, but maybe I shouldn't suggest this because if someone else is going to get the ownership, that's someone's taking something from me. So generally people involved in theatre don't think about things in that way. But it's clear there's a lot of collaboration that happens. It could be the director suggesting a scenario, it could be the actor suggesting lines, changes to the character. A character's whole kind of being could change through these workshops and rehearsals. And so the ultimate point is that when the play is performed, all of this has contributed. So the writer has put a structure in all of this, but the director has been involved. The actors have been heavily involved in this collaboration. And the play, as it is eventually performed, will reflect this process very profoundly. And so you could actually argue under copyright law that this is a work of joint authorship, not a single work that should belong to the playwright. So as I said, theatre is a very diverse medium, and there are different ways that plays get authored. You have the very clear case of an individual playwright writing a script more or less from scratch by themselves, bring it to the theatre, some rehearsals, maybe some edits, and then that's it. But lots of theatre gets devised in this highly collaborative way. And so the question is then, for the law, where, as I said, the tradition has been that playwrights have got the credit and the copyright at the end of the process. What should the law do? Should the law actually acknowledge more the collaborative nature of this? And there's also an element of theatrical practice which is quite interesting, which is that when plays are being devised in this way, there are sometimes contracts between different parties. And I'll come to how that element works in just a bit. But before I do, I want to tell you about an important case. So as I said, we have very few cases in the UK on theatre. We have one really brilliant case which reveals a lot of these issues from 2004. Brighton and Double Joint against Jones. And this case really put the workshop process of theatre into the public eye. So this case involved Pamela Brighton, who was a theatre director, and Double Joint, which was the theatre production company based in Belfast, in Ireland, in Northern Ireland. And they essentially commissioned a playwright under contract to write a play for them for a summer production in 1996. The play was called Stones in His Pockets. And it's a kind of comedy, satire of different perceptions of Ireland in Hollywood. I'm sure you could imagine a similar play being written about perceptions of Mexico in Hollywood, right? So the reality of Mexico is different to the Hollywood portrayal. And similar to that, the reality of Ireland is different to the portrayal of Ireland in Hollywood. So that it's kind of a satirical comedy talking about how these Irish boys meet the Hollywood producers of a film set in Ireland, and they have some kind of comedy lines, and it's all very funny. This play was produced in Belfast in 1996. It was moderately successful. It ran for the summer, and then everybody thought that's the end of it. And it's worth emphasizing that this is the life of most plays. Most plays are written, produced once, and then never again. It takes something special to actually have an afterlife, a second round of performances, third round, fourth round. And in this particular case, that did happen. So in 1999, the playwright, Marie Jones, rewrote the play a little bit and produced it again. And this time, it became a massive success. Mm-hmm. It became a hit on the West End of London. It transferred to Broadway and was a massive hit there as well. And every so often, this play gets produced. Every few years, you see it come up again in the London West End, sometimes Broadway. It's a popular play in Europe and the US. So suddenly, there was a pot of money involved. And as I said, usually in theatre, this doesn't happen. It's rare that you get a play that makes so much money. This one was very successful. And so the original theatre company and the original director said to themselves, hold on, we were integrally involved in the way this play was created. And yet now all of the royalties are going to the playwright because, as I said, the convention in theatre is that the playwright gets the copyright in the play. So the case was founded upon two claims by the director, Pamela Brighton. She claimed, number one, that she had made a lot of verbal contributions during the workshop process that have added to the play. So edits, suggestions of lines of dialogue, character changes, that she was essentially integrally involved in the creating of this play during the workshops. As I said, the actors, the director, and the writer are all in the same room. They're all working towards the end version of the play. So she said that she did that. And she also claimed, interestingly, that when they commissioned the playwright Marie Jones to come up with this play, initially there was a delay when Marie Jones had writer's block. And so at one point, the theatre company and the director got very worried. They said, we have to produce this play in 1 month, and we've heard nothing from the writer. And they began to panic a bit. So to try to provoke the playwright to start writing, she actually wrote down an opening scene herself and faxed it. This is back in the 90s, so they used fax machines, to the playwright. And interestingly, she claimed that that opening scene was still visibly there in the final play. So it wasn't identical to the opening scene of the actual play, but it was still visible. The characters were there, some lines of dialogue were there, and so on. And the theatre company itself said that under the contract they signed with Marie Jones when they commissioned her, they were actually entitled to be credited as the original producer of the play whenever it was produced again, and they were entitled to a certain amount of income. So there were three legal issues here that are of great importance. First one, was the director, Pamela Brighton, a joint author of the play under the copyright doctrine of joint authorship due to her verbal contributions during the workshop process? Number two, had the playwright infringed upon the copyright in Brighton's draft script that she'd faxed to Marie Jones and that Marie Jones used to draft the first scene of the play? And obviously then the play as it would finally be would be a derivative work of that initial scene of Marie Jones. So that was an interesting question as well. And number three, whether the theatre company was entitled under contract to a percentage of income and to be credited. That was a more straightforward question because you had the contract to fall back on. Now, I'll go through each of these three questions in turn. First one, under the copyright doctrine of joint authorship in the UK, the rule is that you have to make a significant and original contribution towards the creation of the work. Here, the court explicitly said that the director, Miss Brighton's contribution, though important, was not of the nature to make her a joint author, according to the law. One of the problems for the director here was that she only had oral recollections, verbal recollections of what she had said. There was no actual evidence that she could rely on. For example, nobody had recorded these workshops. Nobody had really written down who was adding what at any point. And so the court in London said, because there's no written or recorded evidence here, we're relying on one witness says this, the other witness says this. It's not reliable. And on this basis, we're not going to find joint authorship. And that seemed to be that for that point. But when we come to the second point, we found that there was something the director could rely on. Because remember, she had faxed this opening scenario to the playwright. And here, luckily, she had kept the fax, the original notes that she had faxed. And here she had written evidence. And as you know, many of you are lawyers, the courts like written evidence. They don't like verbal witnesses contradicting one another with nothing else. Here there was a written document that Pamela Brighton could say, look, I wrote this, and then look at the script of the finished play. And so here, the court did say that Pamela Brighton had a copyright interest in the play because the eventual script of the play that had become very lucrative and was being performed worldwide was derivative of this initial script. But they said, but of course, you impliedly authorized that the playwright could use this because you faxed it to her and said, use this to begin it. So they said, because of that, you essentially gave a license to the playwright to use this first opening script that you gave. And you only rescinded that license when you took this legal action. So what this meant was that Pamela Brighton, yes, was acknowledged as an author of that original work. She was entitled to an interest in the final work based on the original notes she'd sent, but that she could not claim royalties for the past performances because she had given this license, this authorization to the playwright. However, for future performances, the court was stating that now the license has been revoked. So now, for future performances, the playwright must actually agree to share some of the revenue with you, Pamela Brighton. And then the third point, which as I said was relatively straightforward because the contract actually specified that the theatre company Double Joint should be entitled to credit as the original producer. and was also entitled to a percentage of income from the play. So that was all dealt with in a relatively straightforward sense. Now, what this case highlights is how collaborative the medium of theatre is. Not just the performance on stage, but the way the whole play is authored and created in the first place. It also shows the law. The law of copyright is quite conservative when it comes to proving claims of joint authorship. In a collaborative medium, when people are claiming different things, the courts will generally leave the authorship with the original owner unless there is clear written evidence or recorded evidence to the contrary. So verbal recollections from many years previously will not suffice as evidence. And without that evidence, to help with legal certainty, the law will tend to allow the original copyright to remain with that first author. Now, as I said, very few plays make significant profits. That's why we have so little case law. But we do have some interesting cases that have made the news. There are New York Times articles about these cases, Guardian articles about these cases. The famous musical Hamilton right now is a huge success on Broadway and the West End in London. The original writer of that musical agreed to share a certain percentage of the royalties with the original cast of Hamilton. So Lin-Manuel Miranda is the writer of Hamilton. He accepted that the initial cast had added so much in the workshops as the play was being written. You know, lines were edited, suggested, characters were changed slightly. And that original cast will get a percentage of the huge revenues of Hamilton. I think it's quite a small percentage. It hasn't been confirmed in the media, but it's thought to be around 1-2%, so it's a small amount, but a small amount of a massive amount of money, then shared between the cast. But only the original cast, not the subsequent cast, because only the original cast was involved in the way the play was written in these workshops. And similarly, Angels in America, another incredibly famous play written by Tony Kushner in the early 90s, he decided to share some royalties with the original cast because he accepted. They added so much. It was a collaboration with them in the way this play got authored. So we do have some examples where these playwrights have not shared the credit in that there's still only one author credited. They still own the copyright, but they have decided to distribute some of the income, some of the revenue, to the original casts to acknowledge the collaborative role in the way these plays were created. So it's not just about fighting for the authorship in terms of copyright law. There are other ways that these kinds of disputes can be resolved. That the collaborative nature of the creative, the creativity, the authorship, can be acknowledged through revenue sharing as well. So that's the way that they have dealt with it. As I said, we don't have that much case law, but it's certainly true that you can find examples, like with Hamilton and Angels in America, where playwrights have decided to acknowledge this is a collaborative type of authorship. And that brings me to the second part of my presentation, which is about infringement. The theatrical medium relies upon reinterpretation of old myths, of old tropes. As I said, the revenge idea, the love triangle, and then everything upon that. A lot of influences happen. There's borrowing, there's copying. At what point does taking influence from someone go too far and become copyright infringement? In other words, how much can you take from another playwright's work before it becomes copyright infringement? Now, obviously, there's no problem where you have a public domain work. So if it's Shakespeare, if it's Chekhov, you can take as much as you like because the play is in the public domain. But where it is in copyright, then you have a potential problem because you may be committing infringement. And here I'm going to rely on some examples from the interviews that I undertook about the way in which these kinds of disputes have come up in theatre. First, let's look at the law. So under the CDPA 1988, the UK Copyright Act, a person will infringe copyright if, without having obtained a license, he or she exercises one of the restricted acts: adaptation, performance, so on. So that's a long-winded way of saying that if you use the work without permission, that's infringement. Now, importantly, in section 16.3, down the bottom of my slide, this applies to the work as a whole or a substantial part of it. And a substantial part is qualitative, not quantitative. So even if you only take, let's say, 10% of the play, but it's the most memorable part, most memorable lines of dialogue, for example, then that will be infringement. So even if you only take a small quantity, but the quality is high, that will be infringement. So you need to be able to demonstrate that part of, in order to show that someone has infringed a work, that they've taken a substantial part of it. They've taken some of the original creativity that you worked so hard on, and they've taken it without permission. So we have some case law that tries to determine what exactly is the substantial part. What guidance do we have? Well, as I said already, it is a qualitative test. And an interesting case we have in the UK from 2006 involves the famous novel The Da Vinci Code. And I don't know how many of you have read The Da Vinci Code. It was enormously successful about 10 years ago. Mm-hmm. And there's, obviously they made the film of it as well. So again, you only get these cases where there's an enormous pile of money at the end of the rainbow. So here the claim was that in the 1980s, the writers of a historical book that, oh, by the way, I'm going to spoil the plot of the Da Vinci Code now. I have no choice but to explain it. So for those of you who haven't seen it, I'm sorry. Lo siento. So in the Da Vinci Code, the plot is based around the idea that Jesus Christ had a family, had children, and therefore had a bloodline. And that the Holy Grail that is talked about in Christian mythology is actually simply the bloodline of Jesus. And that Jesus has descendants that are alive today, and they are the ones whom the church is secretly protecting. So it's kind of this historical idea. And the interesting thing is, in the 1980s, two historians came out with a work called Holy Blood, Holy Grail, where they made this exact historical argument. They didn't have a lot of concrete evidence, but they had some reasonable pieces that they could make this claim. I mean, for example, if, for example, Jesus Christ lived to the age of 30, the argument they made was that in the Middle East at that time, it would have been almost unthinkable for a man not to be married, not to have children by this stage. So again, they pieced together various different elements and they made this claim. Dan Brown, then the writer of the Da Vinci Code 20 years later, used this as the central idea around which he built this thriller about how this professor is uncovering this mystery. The search for the Holy Grail is actually a search for the descendants of Jesus Christ. And obviously when this became a huge success and there was a ton of money, many millions of dollars of revenue, the original author said, well, he has infringed our work. And the UK courts interestingly said, well, no. You cannot have copyright in a historical idea. And Dan Brown has not taken any of your words. He's not copied and pasted your text. If you look at the two books, the words are not in the same category at all. One is a work of history, and one is a work of fiction. And yes, you might have been the ones who came out with this historical theme, but a theme in itself is not protectable. You need to talk about, show me where the characters are taken. Show me where the lines of dialogue are taken. Show me where the detailed plot is taken. All of that was original in Dan Brown's book. And so, it's a really good example of what you can take, which is these general ideas, and what you can't take, lines of dialogue, detailed characters, detailed plots, and so on. And this would similarly be the case in a dramatic format. Furthermore, we know from recent EU case law that even taking a few sentences could amount to copyright infringement. In the famous case of Infopac in the European Court of Justice, they said even 11 words could be infringement if it is actually qualitatively a reflection of the creativity of the author. So not in every case will 11 words be original enough for it to be infringement, but there could be cases. And if you think about, you know, your favorite line in a movie, you know, think about things like, you know, hasta la vista, baby, right? or I'll be back, or here's looking at you, kid, or you can't handle the truth, right? Some of these are so important within the context of the film. So they seem to be saying that if you take something so important, it could be infringement. And the UK courts have kind of accepted that in the literary context, so newspaper headlines, short pieces of text. And there's no reason why that couldn't be applied in the case of dramatic works, because you're again talking about lines of text, dialogue, and so on. Now, I couldn't find many cases at all of infringement in theatre. So I asked the interviewees, and I found a really interesting guy, a playwright in London, who told me this story. He said, I went to see another writer's play at a theatre in London, and after about 10 minutes, I started to feel a bit uneasy because I recognized my own work in this new play. There were a lot of similarities, he said, between a play I had produced in London the previous year and the play that I was watching suddenly on the stage. In both plays, there were two main characters, both men, a young man and an old man, in a kind of mentor-mentee relationship. Both plays centered in the same city. Both plays were based on their relationship as it develops over a particularly important time of environmental change. Environmentalism was a key element in both plays. But there were no direct lines were copied. The characters' names were different. But there was a lot of similarity that he saw in this play. And of course, it wasn't acknowledged at all in the program or in any of the works. So it happened without acknowledgement or license. It happened at a well-known theatre in London, and that was one of the things that he was annoyed at, the playwright, because he said, you know, my play was on at a much smaller theatre, it got good reviews, but it ended its run, and then this play is at a much bigger theatre, and they've clearly taken a lot of my structure, my ideas, the details of my work. And of course, he said, it wasn't even as good as my play. He said it did not do as much justice to the scenario. You know, my characters, my dialogue, my play was much, much more interesting, you know. Here, there were some elements that were in his favor if he wanted to take a case, and some that were less so. As I said, it was not so obvious that lines of dialogue were the same. It was not so obvious that the character names were the same. But there were enough similarities that more than one reviewer of the newer play said, this play is quite similar to a play that was performed last year in London. So it wasn't just his paranoia, it wasn't just his imagination. Other reviewers independent of him had noticed the similarity. And so he was in a situation where he had to decide, you know, is this infringement, and should I take a court case potentially, or at least complain to the theatre and the playwright and try to get some compensation or something? Or was this on the borderline between what is acceptable as borrowing, as influence, and what is simply stealing, let's say? Here, the question of whether it was infringement would ultimately come down to the question of, has a substantial part been taken? It was not impossible to make that argument, because you had reviewers who acknowledged that there were elements very similar between the two plays. At the same time, there were no immediate lines of dialogue that he could point to. So it was never going to be the easiest case to win, but neither was it going to be completely impossible. It was somewhere in between. He had an arguable case, but there was no guarantee that he was going to win. And so, in the end, he did not take any legal action. This decision, he said, was made for a number of reasons. First, he said that in the end, the question of is this infringement was a difficult one. How much similarity was required between the two sets of scenarios, the two sets of characters, the themes, the kind of way the play unfolded. How clear was his legal case? He couldn't be 100% or even 90% sure that he would win. Second, given that he couldn't be sure or truly confident he'd win, he had to deal with the costs of losing. In the UK, taking a copyright case can end up if you go all the way to trial, can cost you many hundreds of thousands of pounds. And if you lose, you will have to pay a portion of the costs of the other side as well. So if you win, you get back some of your costs, but if you lose, you have to pay the other sides as well as your own costs. So it's potentially very expensive. Third, and this was quite interesting, he was worried about setting a dangerous precedent because he said, you know what, Luke, we all borrow from each other in theatre. We all take strong influence from each other. I don't want to be the person who sets the precedent that means everybody is paranoid about being influenced by somebody else, you know. And so he was a bit worried that if this hard legal principle was established, it might actually disrupt some of the free creative practices of people in theatre. And, this was also very interesting to me, he felt there had been some acknowledgement within the theatre community of what had happened. So in other words, there was another way of getting some comeback or some compensation. And this was that the reviewers had noticed the similarity and had criticized the later play for perhaps being too influenced by the earlier one. So people within his network, other playwrights, directors, knew that it had happened, knew that it was probably on the borderline of what was acceptable or not, and had noted it. And he said, in the end, I'm not going to risk legal action because the costs are so high. I'm a creative person. I don't want to set this precedent that could end up disrupting creativity. And you know what? People know that it's happened. I'm satisfied enough. I'm not happy that it's happened, but I'm satisfied at least that other people have acknowledged this was wrong.
Shame.
Shame, exactly. The idea of some sort of shame exactly within the community, right? The second example I had was actually about choreography. And I interviewed a director and a producer from a theatre company that is quite famous in the UK for producing really innovative dance. And he was watching television one evening, on a Saturday evening, and on one of the major British channels where there was a kind of dance competition, like the first case I told you about, he started to feel a bit uneasy because he said, hold on a second, those are our routines, you know, those are our dances, we choreographed that, and now it's on national television. And we haven't been asked about it. We didn't give our permission. And he said, virtually the entire choreographed routines had been taken. And as I said earlier, you can have a work of dance protected as a dramatic work under copyright. It doesn't have to have words. You can have a sequence of dance moves. It's artistic. It can be protected under copyright. It's a creative work. So it was certainly possible that his work had been infringed by the use of it without permission on national television. So it happened without acknowledgement. It happened in a context that was commercially important. You know, he was saying, you know, we could have got thousands of pounds as a license fee for the use of that had they asked us, you know. Other people as well, similar to the first case, had commented on the similarities, you know. It's fascinating to know how, you know, we're all in the legal world. We know what's going on in the law and when this case has been fought and who the lawyers were and that sort of thing. Similarly, in the theatre world, they know what's going on. And so here, he said, we actually got phone calls from people to congratulate us. They said, I saw your work on national TV. That's amazing. That's great. And they said, yeah, they didn't ask for our permission. They didn't pay us for it, you know. So again, he was in a situation where they were a relatively small but well-known theatre within the dance world in the UK. This more commercially large-scale possible infringement had happened. How should he react to this? How should his company, his theatre company, react? Here he had to again establish, is this legally a case of infringement, or have they just taken influence from my work? Here, I said to him, I think you have a strong case, because if they've taken an entire sequence, a choreographed sequence from you, and if you have recorded that sequence either as a description of moves or perhaps through filmed routines at your theatre, then you would have some evidence that you had created this work and suddenly it's on television. But even so, even though I thought they had a relatively strong case, in the end they still didn't take any legal action. And again, they made this decision for some well-reasoned points. First, even though I said to them, and they acknowledged that yes, routines were taken, they themselves were a little bit unsure of how they could establish this point 100%, because they said, you know, okay, the whole routine is there, but it's not 100% the same. You know, it's 90% there, but every so often there might be, for example, they might move left rather than right. So like the essence of the routine is there, but there are a few moves. I mean, without clear cases, we don't know whether you need the entire 100% sequence to be taken, or whether just taking a lot of it will do. We don't have a clear precedent for this in the UK, because it's so rare for choreographed works to come up in the court. So even though they had a strong case, they still didn't want to take the risk, because of course the costs of losing are dramatic. How much similarity is required? They couldn't be sure enough that it would be worth their while to risk losing and having to pay the costs. And finally then, they also were worried about setting a dangerous precedent, because they said, you know, works of dance are by their nature based on things people have done before. You know? Think about works of modern dance that are based on classic salsa dances or classic Mexican ballet dances. You know, you can recognize the genre of the dance from just a few moves, but of course there could be some new elements as well. There are certainly some possible dangers for dance to having strict rules in place, because you want there to be a free and creative culture in dance. You don't want everybody to be thinking, oh, I won't do that because it's too close to what Michael Jackson did or whatever. You know? Now, since I did these interviews, there has been one major dispute that was settled out of court, which was a dispute between a Belgian choreographer and Beyoncé, where one of Beyoncé's videos, it made the headlines a year or two ago, ended up using a routine that was very similar to this Belgian choreographer, and that was settled out of court. So there, where you had a high-profile Belgian choreographer and a multi-millionaire recording artist, they just, behind the scenes, settled it. This theatre company didn't feel as confident to try to they didn't feel as powerful, potentially. And they were afraid of setting this precedent. So in the end, they didn't go to the law. So where does this leave us then as lawyers, given that we've discovered that actually a lot of the ways that we say plays are authored are problematic, and actually it's mostly a collaborative medium? How do we deal with this? Well, one of the things the interviews said to me, nearly all of the interviews, the interviewees said to me, even though we acknowledge it's collaborative, we still respect the role of the author. You know, there's a real skill at shaping a work, at putting structure on it. And the interesting thing that they said with regard to the way that the economics of theatre works is that playwrights are often not paid that much for their work. The theatre director will often be internal to a theatre company or will be paid a fee to direct it. The actors will be getting a union rate, or if they can negotiate something above that, they'll do that. The playwright won't get much money at all for putting on the play. But they will get the copyright. So the playwrights that I spoke to said, I feel that's what I'm owed with the work that I do in theatre. I don't make money from this, really, you know. I'm just about able to continue with my work through subsidies, through other things like that. But by getting the copyright, at least I feel I have something that I can use in the future, that in the unlikely event my work does become successful, at least I have that. So there was that interesting way that the revenue, I guess, elements and the economics of theatre work that, and as well, of course, actors might move from role to role and get paid with each role they do. A playwright might just write one play every couple of years and get one fee, which might only be, at a small theatre, maybe £1,000, or even it could be less, or it could be a bit more, depending on how large it is. So getting the copyright, they really felt, was their reward for all of this. At the same time, the majority of interviewees, and as I said, they were doing different roles in theatre, had experienced at least some situations where they felt they should have been acknowledged in some way as a creator of the work. And so they had felt it would have been fairer and more just if they had been recognized in that way. But of course, it doesn't always occur. We have cases like Hamilton and Angels in America where it certainly does occur, but there are cases where it doesn't. And of course, as well, imitation occurs. Taking influence from somebody else's work occurs. It's a necessary part of the creative life of artists. Adaptation, homage, interpretation. From the examples I've given you, I think we can see that at times, however, this imitation, this interpretation, comes very close, crosses the boundary, perhaps, of copyright infringement. But, as I've said, artists are wary of taking legal action. You know, as lawyers, we always think, oh, if someone has infringed your rights, sue. Mm-hmm. But of course, we need to think about the calculus of why people would take legal action or why they wouldn't. It isn't always about whether you feel aggrieved or unhappy. It's also about, I mean, some artists said to me, imagine, you know, I work myself to the bone to be part of the art scene. I don't make a lot of money out of it. Most people don't. I'm not going to spend months of my life pursuing a legal action. Yeah. It's a waste of my time and my creativity to do that. And so, you know, perhaps we as lawyers should also think about the ways in which people in the creative industries, you know, what are their incentives? What are their real reasons for doing what they're doing? And how can the law actually do more? Or are some of these informal ways within theatre that allow, for example, the reviewers even to acknowledge this one has kind of nicked a lot from that previous play, has stolen maybe? Is there a form of self-regulation where it's acknowledged within theatre this has happened, and that can be enough for those within the field? So, that's all I want to say at this stage. I'm, as I said, very honored to be here. I'm in the process of writing a book about all of this. So I'm very, very interested to hear your thoughts and also the thoughts of the other panelists. Again, thank you so much, and I welcome your comments.
Well, thank you very much, Luke, for a very, very, very enlightful presentation. Now I'm going to do like a super short summary of it in Spanish. Bueno, nada más para dar un resumen y a ver si podemos llenar un poco de los puntos que no hayan sido completamente entendidos. Voy a dar un resumen de lo que acaba de exponer Luke y después voy a dar paso a Laura y a Luna para que comenten al respecto. Bueno, Luke nos está hablando en general sobre una investigación que él hizo en el mundo del teatro para ver qué es lo que causa a las personas a crear dentro de una obra dramática, ¿no? Nos dice que el proceso de creación de obras de teatro no es tan directo como el de ser un solo autor de un libro, de una obra literaria, de una pieza de pintura, etcétera, ¿no? Porque, bueno, se da en el teatro del caso, que es una autoría Nos dice, bueno, la gente que trabaja en el teatro tiene a veces, muchas veces, más de un solo rol dentro de la producción. Normalmente quien es el productor termina siendo también director, quien es director termina produciendo, escribiendo, los actores incluso terminan siendo parte de la creación del teatro. Entonces, el primer punto era saber quién es el autor dentro de una obra de teatro, ¿no? Primero nos dice, bueno, ¿qué es una obra dramática? Las obras dramáticas no solamente son aquellas que son consideradas que tienen un trabajo quiero decir líneas, pero con diálogo, sino que también son consideradas aquellas que tienen danza o mímica, ¿no? Las que carecen absolutamente de diálogo también son consideradas obras teatrales, pero que pueden ser interpretadas o representadas y que se basan en un libreto. Nos ponía el ejemplo de que un partido de fútbol, por muy dramático que llegue a ser, pues no es una obra de teatro porque no sigue una línea, un guión. Y pone en cuestión si la lucha libre puede ser o no puede ser una obra de teatro, si realmente hay un guión o no. Eso, bueno, lo dejamos a consideración del público. Entonces, además del guión, tiene que ser la obra dramática, para ser considerada una obra teatral, capaz de ser representada, ¿no? Como ya decíamos, no solamente con un guión que siga una línea de argumentos, sino también puede ser con mímica y con danza. Entonces, para que las obras sean, bueno, hablaba de los trabajos creativos, una muy directa forma de saber que son trabajos creativos. ¿Cómo llegan las obras al teatro? Decía, si van a un teatro grande, si van a un teatro muy importante, normalmente la obra llega ya completamente armada. Normalmente la obra ya llega con un guión completamente escrito y armado, y pues eso es muy directo, de alguna forma, para saber definir quién es el autor de esa obra, pues quién escribió el guión. Pero en el mundo del teatro se da muy a menudo que las obras de teatro no son simplemente un guión que está escrito y ya. Si nos hablaba de no supe traducir Fringe, el teatro Fringe. A lo mejor la gente que está aquí, que sabe más de teatro que yo, nos puede decir, ¿no? Llega una obra en crudo, en donde se sientan actores con productor, con el escritor, con la gente que trabaja en el set, y es un trabajo de equipo en el que todos colaboran y todos aportan y terminan haciendo la obra final, que podría incluso llegar a ser muy diferente a lo que la obra teatral en crudo empezó. Entonces, pues sí, porque puede haber muchos cambios. Entonces, la mayoría está concentrada en este proceso de creación, cuando se sientan él le llamaba los workshops, ¿no? Que lo tradujimos como talleres. En este tipo de workshops aportan todos los que van a participar en la obra de teatro, y todo mundo durante este proceso pues está interesado en sacar la obra de teatro adelante. Nadie está interesado con, a ver, no, apúntale ahí que yo escribí esta parte y esa es parte de mi creación. No, todo el mundo está enfocado en la creación de la obra de teatro y que salga la obra de teatro final, ¿no? Entonces, pues desde la perspectiva de derechos de autor, este trabajo colectivo puede ser considerado coautoría, ¿no? Como viene la definición dentro de un código. ¿Y qué debe de hacer el derecho? Si reconocer que existe este tipo de coautoría, ¿no? De joint authorship le llamaba. Nos hablaba entonces primero de un caso de Brighton y Doubleton contra Jones, en donde una casa productora le pidió a esta escritora Jones que escribiera una obra de teatro. Y Brighton era la actriz, Doubleton era la productora y Jones era la escritora, ¿no? Entonces llegó un momento durante el proceso creativo que la escritora tuvo un bloqueo y ya no sacó la obra adelante, a pesar de que la productora le había escrito. Entonces, de alguna forma, para impulsarla a que siguiera escribiendo, una de las actrices se puso a escribir la primera escena de la obra y dice, bueno, en los 90s se la envió por fax a la escritora, y ya de ahí la escritora le dio vuelo y presentaron la obra en un teatro pequeño en los 90s. Después la escritora se puso a, digamos, reescribir el trabajo original y sacó una obra que resultó ser un súper éxito. Tanto en West End, en Londres, como en Broadway, se hizo una obra muy famosa que empezó a tener muchas ganancias. Ahí en ese momento fue que la productora y la actriz principal, me imagino, was Brighton the principal actress in the case? She was the director. Perdón. Había estado diciendo que era actriz, pero no era la directora. Brighton era la directora. Y entonces, en ese momento inician una acción legal en contra de la escritora para pedir que les hiciera partícipes de las regalías que ella estaba obteniendo, ¿no? Entonces, nos hablaba de que principalmente fueron 3 preguntas las que se pusieron ante la corte. La primera era si Brighton, la directora que había escrito una parte y que había aportado verbalmente mucho a la obra, si estas aportaciones verbales al desarrollo de la obra de teatro podían ser consideradas suficientemente sustantivas como para considerarla coautora. La segunda pregunta era si esta escena, primera escena que Brighton había escrito para impulsar a la escritora a que escribiera y que se quitara del bloqueo, podría ser considerada, bueno, parte de, o sea, como la obra principal y que el trabajo final fuera el trabajo derivado de la escritora. Y la tercera pregunta era si la productora podía reclamar o no un porcentaje de las ganancias, porque eran los productores originales, ¿no? Porque si la productora no le hubiera pedido, o sea, un poco ese es el argumento, si la productora nunca le hubiera pedido a la escritora esta obra, pues la obra nunca hubiera existido, ¿no? De alguna forma lo podríamos asimilar como una obra por encargo. Entonces, bueno, la Corte decidió que en cuanto a las aportaciones verbales de la directora, que la contribución tenía que ser significativa para poderla considerar una coautora. Y la Corte no aceptó la evidencia de testigos porque realmente era como una persona en contra de otra. Y Luke nos decía, bueno, a la Corte tampoco le gustan mucho las evidencias verbales que puedan existir, quieren ver como cosas más contundentes, y realmente cuando uno tiene testigos es la palabra de una persona contra la otra. Entonces, por mucho que hubiera hecho en aportaciones verbales la directora para que se hiciera el trabajo final, pues no tenía forma de probar que ella hizo estas aportaciones. Entonces eso quedó como desechado. En cuanto a lo segundo, sobre escribir la primera escena, dado que sí tenía ella el fax original de lo que escribió en la primera escena, ahí sí se lo permitió la Corte, pero le dijo, ojo, tú le diste una licencia, es como haberle otorgado una licencia de uso sobre tu trabajo a la escritora. Licencia que reconocemos que ahorita con esta demanda estás revocando. Entonces, a partir de ahorita que estás revocando la licencia, tú puedes pedir regalías, pero no puedes pedir regalías sobre lo que ya habías dado licencia, ¿no? Sobre lo anterior. Y bueno, en cuanto a la tercera pregunta, sobre si la compañía de teatro podía pedir un porcentaje de las ganancias, sí tenían derecho a que se le nombrara como créditos de la obra original, pero en realidad no habían sufrido ninguna pérdida por el resultado de que no se les hubiera nombrado antes, por lo tanto no tenían derecho a recabar ningún daño. Entonces, bueno, nos dice Lu que después de este caso podemos decir que la Corte es muy conservadora para probar una coautoría y que una prueba verbal, pues, por ejemplo, no es suficiente, ¿no? Luego nos dio también el ejemplo de este autor Tony Kushner, que es director de varias obras teatrales, que él sí reconoció que todo su equipo estuvo ayudándole durante todo el proceso creativo de la obra y él sí compartió las regalías con su equipo, pero no porque la ley lo obligara, digámoslo así, ¿no? Ni porque una corte lo obligara, sino porque él como director reconoció que en el proceso creativo de la obra estuvieron todas estas personas y sí les hizo parte en cuanto a las regalías. Luego hablamos un poco sobre qué tanto se puede, hasta qué punto se considera tomé inspiración de una obra previa y hasta qué punto esta imitación es considerada realmente una infracción. Entonces, nos dice que uno de los puntos principales es que para que sea una infracción se tendría que utilizar el trabajo sin permiso, bien completo o bien una parte sustancial. Es donde se pone un poco difícil definir qué es una parte sustancial, ¿no? ¿Qué entiende la ley? O sea, bueno, se ve muy bonito en la ley decir que si tomas una parte sustancial sin permiso, entonces sí es una infracción. Bueno, pero ¿qué significa una parte sustancial? Y en realidad, pues, estamos hablando que es un test cualitativo, ¿no? La Corte no puede definir si tomaste tanto porcentaje, no, sino que es más bien un test cualitativo más que uno cuantitativo. Entonces nos ponía el ejemplo de que en los 80s existía una obra sobre el Holy Grail de la cual Dan Brown tomó pues referencia o se inspiró para luego escribir el Código Da Vinci, que terminó siendo una obra, bueno, no nada más un libro que fue bestseller, sino también una película que recaudó muchos millones de dólares. Entonces, cuando ya hay dinero de por medio, la gente se anima a demandar, y estos primeros autores de los 80s demandaron que Dan Brown pues había copiado sus ideas. Y lo que la Corte decidió en este caso en concreto es que, dado que la obra de los 80s se basaba en datos históricos, pues que no se podía reclamar derechos de autor sobre datos históricos, que si bien ellos habían sido los primeros en tomar en cuenta este tipo de hechos históricos para poder escribir una obra, pues ellos no podían reclamar derechos de autor sobre cosas históricas que habían pasado, y que en realidad el trabajo de Dan Brown pues era muy auténtico, muy creativo, pues porque él ya le metió una línea de drama en medio, ¿no? Con personajes concretos, con un argumento muy en concreto. Nos pone también en este sentido el ejemplo de que sí se ha llegado a considerar infracción, incluso 11 palabras se ha llegado a considerar infracción de derechos de autor cuando son palabras muy representativas de un trabajo, ¿no? Cuando son palabras que son claramente, como nos decía, yo nomás me acordé con el hasta la vista baby, porque justo estábamos platicando antes de venir que nadie dice eso en México. Y entonces, bueno, cuando es algo súper representativo que la gente podría… que la gente puede identificar como exclusivo de una obra, pues sí puede llegar a considerarse que si la tomas es infracción a derechos de autor. Bueno, y después de eso nos comentó de 2 entrevistas muy interesantes que tuvo en el mundo del teatro con personas que eran creadoras y que de repente vio en una, era muy en concreto con una obra de teatro y la otra con una coreografía, y que las 2 personas, los creadores o los autores originales, reconocieron en esta nueva obra o en esta nueva coreografía, reconocieron su propia obra y dijeron, a ver, ¿cómo? No están copiando ni el nombre de mis personajes, ni los nombres de mis personajes, ni ninguno de las, tal cual el guión principal, pero toda la idea y en esencia es lo mismo. Y no era la paranoia de estos autores, sino que incluso muchos críticos de teatro en un caso y expertos en danza en el otro, reconocieron la similitud, dijeron, oye, esto es igualito a tu obra, ¿no? Pero en los 2 casos nos habla sobre que los autores principales pues no quisieron llevar a la corte estos casos de como una infracción, y bueno, pone varias razones interesantes. Yo creo que una de las principales o que más me llamó a mí la atención es que, bueno, para empezar, una es muy simple, que tiene que ver con el dinero. Si pierdo, tengo que gastar muchísimo dinero en abogados, en costas procesales, gastos y costas procesales que yo tengo que pagar, ¿no? Y luego, en segundo, no quiero ser esa persona que lleve a la corte un caso de infracción por imitación, porque entonces ¿hasta dónde va a quedar la creatividad? Dice que sobre todo, bueno, que en el mundo del teatro se da mucho y la gente sabe que se toma inspiración de unos de otros, ¿no? O sea, es como un poco parte del proceso creativo entre los creadores del teatro. Pero al final de cuentas, como que ellos estaban a gusto, los creadores, sabiendo que los demás de su gremio sabían que esta persona les había copiado sin darles ningún crédito. Entonces es como, todo el mundo sabe que ellos me copiaron y no me dieron ningún crédito, y como que ese es un castigo o una parte, como él decía, de la forma en la que se autorregula el gremio de alguna manera, y permiten decir, bueno, ¿saben qué? O sea, aunque no me están reconociendo, los demás saben que me copiaron, y pues de alguna forma la comunidad en la que, del teatro sabe que se está llevando a cabo este tipo de infracción, ¿no? Entonces, bueno, y dentro de sus conclusiones finales dice, si está sucediendo este tipo de casos en los que hay, digamos, unas infracciones que son claras y la gente no lo está llevando a la corte, no se está peleando, lo está más bien autorregulando, porque, como decía en un principio, están más enfocados en el proceso creativo que en realidad en ganar dinero en un primer momento, ¿no? Entonces, bueno, pues ¿qué tanto realmente puede hacer el derecho y qué tiene que cambiar para poder ayudar a los creadores, ¿no? A hacer eso, a crear. Entonces, bueno, ahí lo dejo para dar paso a Laura y a Luna que comenten.
No, muchísimas gracias, Ana, por la invitación, y muchas gracias a Luc por la fantástica exposición y por esta gran investigación que creo que nos abre muchísimas opciones para justamente desarrollar y reflexionar en torno al papel del derecho dentro de estas situaciones. Me voy a permitir hablar en español porque mi inglés no es fantástico y voy a tratar de ser lo más concisa posible para que puedas traducirle a Luc lo que le quiero plantear. Bueno, un poco retomando sobre todo las últimas ideas planteadas. Creo que existen movimientos bastante de las últimas décadas, a lo mejor de los últimos 20 años, en los cuales se habla de nuevas teorías o nuevas concepciones teóricas como son los procomunes, ¿no? Que tiene que ver un poco con estas creaciones creaciones que son de todos y no son de nadie. Pueden ser tanto creaciones intelectuales como procomunes. También se entiende, no sé, el aire, el agua, o sea, bienes que en ciertos puntos, porque no siempre el agua sí tiene luego propietarios, pero puntos que digamos son de todos y no son de nadie, no son propiedad privada ni del Estado ni de empresas en particular, y entonces esto se le conoce como procomunes y existe todo un movimiento que ha desarrollado pues análisis en torno a estas ideas, y dentro de los procomunes encontramos las creaciones. En este sentido, es un poco como pensar justamente, como se decía en las últimas ideas, que para que a alguien creativo se le ocurra algo ha tenido que leer muchísimos libros, acudir a museos, participar en proyectos colaborativos y en escuelas o cuestiones así, y por tanto siempre existe una dimensión en la creación que es procomunal, ¿no? Esto es lo que nos vienen a decir estos teóricos y estos autores. Y si en toda creación hay una parte procomunal, es absurdo que se le ofrezca la propiedad exclusiva de las ideas a una persona en particular. Y entonces ahí es donde entran también las teorías relacionadas con las licencias libres o los Creative Commons, el copyleft, que trata de proporcionar un herramental a los autores para que ellos mismos, a partir de su derecho moral, decidan de qué manera quieren o no compartir sus creaciones. Y pienso que a lo mejor voltear justamente a estudiar o voltear a ver este tipo de teorías podría ayudar a proporcionar argumentos por parte de los abogados de cara a plantearle a la Corte nuevos argumentos que pudieran a lo mejor ampliar el derecho y la protección de los derechos, o ofrecerles a los creadores un herramental más amplio para que ellos mismos decidan cómo compartir sus creaciones. Y en este caso, donde hablamos de arte colaborativo o de autoría colaborativa, creo que podría ser muy interesante voltear a planteárnoslo justamente frente a estos problemas de licencias, ver cómo se pueden llegar a compartir regalías o ganancias a partir también de las teorías de la economía solidaria, ¿no? Que justamente lo que busca la economía solidaria es encontrar alternativas a las reglas del mercado actual para generar o integrar redes de colaboración en los cuales que por sí mismas estas redes generen un flujo económico. Y entonces pienso que en estos últimos dos ejemplos, si volteáramos a utilizar a lo mejor herramientas como los Creative Commons, es decir, si estas autoras, estas creadoras hubieran registrado con Creative Commons sus obras, habrían tenido de alguna manera una protección mayor a la hora de decidir: me atrevo a ir a los tribunales sin este miedo de perder y con unos argumentos fuertes en los cuales, sobre todo en el último caso, en el caso del contexto de valor comercial y del anuncio publicitario, normalmente las licencias Creative Commons traen una cláusula que dice no se puede explotar, o sea, puedes utilizar mi obra, puedes generar una derivada, puedes utilizarla siempre dándome ese reconocimiento, pero no lo puedes hacer para conseguir un valor comercial que no estés compartiendo con los coautores que hemos participado de ella. Entonces pienso que ese podría ser a lo mejor un camino a explorar o a valorar. Y en ese sentido, mi pregunta para Luke, o así es, la Corte en Inglaterra es conservadora frente a los temas de copyright, un poco por desconocimiento de otras alternativas o porque está de moda el imperio del copyright todavía y no se han planteado otras opciones. Iría un poco por ahí mi comentario. Muchas gracias.
I think I understood a fair amount of that, actually. So thank you, Luna, for speaking very clearly. Even though my Spanish is much better at understanding than speaking.
Thank you.
So if I think I understood you correctly, Anna can.
But if you want, like, we wait for Laura, and
Yeah,
then we
yeah,
can
sure.
put
Yeah.
it together. Yes.
Okay, so first of all, thank you, Anna, for the invitation, and Luke, it was a great and brilliant presentation. I have two questions for you. One is regarding all the examples that you give, the case law, and the examples that you had during your research. What would you think will be the key element or variable regarding whether or not to take a case of infringement to court? Because as we can see in Brighton and Doublejoint and Jones, well, there was money, you know, and revenue and damages and all of that. In the other cases, it seems like there is a balance between, or wanting to be a balance between the recognition of authorship from all your peers, as well as an official recognition, and on the other side is the revenue, whether or not if it is a play that has a lot of revenue or that is very famous and you will get compensation. So would you say money is key, or if it is something else, can we take this element to try to adapt the law to the demands of this of theater, you know? And on another note that is quite different, would you say, for example, that these type of seminars where you have a presentation and could it be translated at the presentation as a script, and this is a dramatical, you know, I know that this is being taped by the Institute, so legally all the rights belong to the Institute, but could you have a claim of authorship, of ownership, given that you did the script and all the guidelines? And well, that is just as a
That is not
curiosity. Yeah.
Not as much as dramatic as we like.
We could make it.
Okay, did you want to add anything else, Anna?
No, at
Okay,
this point,
all right.
yes.
I'll answer Laura's questions first, and then I'll move to Luna and just make sure that I understood everything, and Anna can help maybe. So, in terms of Laura's question about what is the key variable in terms of why do you take a case, what is more important ultimately, the recognition of your peers or the revenue? It's a very interesting question, and it will certainly change from circumstance to circumstance, because as we saw, there's this one case of Brighton and Jones where they did take the case, so they really wanted the money, they wanted the revenue. I highlighted two cases from my study where the recognition of the peers was actually the thing that they cared the most about. And absolutely they wanted the money, but they weren't willing to take the risk of losing the case. And so there's kind of an element of you need to be confident in your case to such an extent that you're willing to take the risk that you could lose and then end up with a huge financial penalty. And in the meantime, as I said, the element of recognition of the peers can actually override the financial element. That's certainly the case in some cases, but not all, as we saw in Brighton and Jones. It's it's one of these things that, like, what can the law? It's a really important question. What can the law do to try to improve this situation? Actually, before I get to the presentation thing, I'll move to Luna a little bit, because if I understood Luna correctly, you were suggesting that maybe Creative Commons or copyleft, these ideas could be influential and could help to provide a solution, right? That perhaps if plays were authored under Creative Commons license, which acknowledged all of the input of different parties, and then they could be licensed so that commercial uses are paid for, but maybe within the theatre scene, they were shared and no one had to pay. Is that correct?
Yes.
In terms of what Luna was saying? Yeah, good. And I think you said it's kind of absurd that an individual gets ownership of something that is so collaborative. Sharing is very, very important. Alternatives to intellectual property are there, like Creative Commons. So, this is one of the ways that the law could potentially try to deal with these complex situations that are not like the classic case of an individual author. There's some definite possible solutions in that, particularly the Creative Commons option. However, it's not a perfect solution either. And one of the reasons is that from talking to these artists, at the moment they have this kind of form of self-regulation, which is very informal. Right? So they're paying attention to what their peers are saying, the critics, other people within the theatre. If you imagine a scenario when everybody is using Creative Commons licenses to set out all of these rights, in one sense, from our point of view as lawyers, that's great, because then we don't have these problems. You have clarity over who is part of the creative team that made this work. You have clarity over what uses can be done by commercial entities, like the TV station, and what uses can be done by small-scale, non-commercial entities like small theatres or something like that. So it has those benefits. The only potential drawback is that it is still a form of legal regulation. It's still a form of formal regulation, and the question is, and I don't know if there's a satisfactory answer yet, is that something that might still hinder creativity in some ways? As soon as you enter into a formal legal licensing arrangement in these ways, might it change the dynamic from at the moment where it's kind of, copyright is something that's kind of ignored until these flashpoints happen. And so everybody's sharing, everybody's free, no one's thinking about ownership until 3 years down the line, there's some money or there's a dispute or somebody has copied your work. So it's one of these things where I agree with you, Luna. As a lawyer, my instincts are, you just need to define all these things more clearly. You just need to have like a creative license or something like that that would allow you to define all of these things so that everyone has clarity. But maybe there's also value in not having everything as a legal formal basis. Maybe there's a value to some forms of just self-regulation, the social norms of reciprocity, sharing are important. And also the social norms, as Anna said, of shame, that it is known that you ripped me off, that you stole from me. I haven't made a legal claim, but it's known that you did that. So, but there's still, in general, the free culture of giving yourself and collaborating in this free sense. So it's, there are definite Creative Commons success stories. Creative Commons has been around now for about 10 years. Some areas it's been really successful. So photographs, for example, Creative Commons has been brilliant. And for whatever reason, a lot of photographs are released through Creative Commons licenses. Some documentary films, some academic licenses are using Creative Commons licenses, really good. But it hasn't, for whatever reason, really taken off in some of these creative contexts, like theatre and some musical contexts, where you would imagine as a lawyer this would be a perfect solution. And some scholars have argued that maybe that's the reason is that any kind of formalization, even a formalization that seems to give a lot of freedom, is a step too far for some creative contexts. So I don't, maybe it will happen slowly over time, but as I said, it is a little bit of a mystery as to why Creative Commons licenses are used so much, for example, in art photography, but not at all in art theatre, So it's really definitely worth exploring more, and it's something that I'm going to grapple with as I take this project forward. But I can understand that there's nervousness from people within these creative communities about really doing anything to change what is the general thriving creative context. So I can understand, my lawyer's instinct are completely to agree with you and not to really understand them. But trying to think outside of the box as a creative person, maybe there's some sense in not having legal rules everywhere, if you know what I mean. So it's a very difficult scenario. And I think that, you know, it flows a bit to Laura's point about presentations. I mean, a lot of what we do in academic presentations and these kinds of, you know, we're all giving our time this evening. You are as well to come and participate. I had never thought about, oh, this is being recorded, maybe I have some rights. I've written a presentation, maybe it's a script. I mean, under the law, you know, what I've written could be protected because my script wrote it, but then Laura and Anna helped to do the translation, the Spanish translation, so they would have some rights as well. And, you know, then, you know, you have added a lot of comments, so have you, Laura. So, you know, if we pay too much attention to who is owning what, then, you know, would we even have these sharing kind of conferences and seminars where we're willing to answer questions and give of our information? So all of these things could be protected, you know. One of the things about copyright that's interesting is that it applies automatically, you don't have to register it. So, you know, even the notes I've been scribbling based on Luna and Laura's comments could be protected by copyright. But it's only, and this is where, again, Laura's point about the money becomes important, because it's only when there is some potential lucrative scenario or some money when really you need to get the courts involved. Before that, like my copyright work here is not valuable. So what, you know, I could potentially sue UNAM for broadcasting this, but why? Why would I do that? You know, so you know, your comment about that is useful even for us as academics to think about, why do we do the things that we do? Why do we share? Why our research? You know, why do we participate in these kinds of events? We believe as well in an idea of sharing and of that we can learn from one another. And so that's why we do that. We don't kind of try to keep our ideas just to ourselves. You know, what would be the point of doing that in academia, and what would be the point of doing that in theatre? So, as I said, all of these things could be legal rights when it comes to academic presentations, but, you know, we should ask ourselves, just because it could be a legal right doesn't mean you should try to enforce it, you know? And that seems to be one of the points that the interviews that I've done, one of the points that's come out of the interviews, that even in situations where people might have had a strong case, they might have a good reason for not enforcing it. And it could be that something like Creative Commons in the future develops as a way of helping these communities to regulate themselves even more efficiently, or it might be that they have good reasons for just keeping the law away as far as possible. So I'll leave it at that and see if you want to say anything else.
Yeah, thanks, Luke. Bueno, ya nada más para hacer un poquito de resumir lo que acaba de decir también ahorita, nos hace un poco como la referencia de, ante la pregunta de Luna de por qué no regular de una manera diferente, alternativa, como los Creative Commons, las obras teatrales. El hecho, bueno, la opinión de Luke es que sí, ciertamente los Creative Commons han funcionado súper bien, por ejemplo, en el mundo de la fotografía. Aún no han sido usados en otros ámbitos de obras que son protegidas por derechos de autor. Y él, bueno, pone la pregunta de qué tanto realmente tenemos que regular, porque lo que él toma de las entrevistas que hizo y de este trabajo de campo es que los procesos creativos pues realmente no necesitan o ignoran un poco las oportunidades que existen desde el punto de vista de derecho para proteger su proceso creativo. Él dice, bueno, yo como abogado también mi primer instinto sería, bueno, si no te está funcionando una forma más directa de protección de registro de derecho de autor, ¿por qué no tomar una forma como el Creative Commons, ¿no? Que es una forma alternativa, pero que al final de cuentas es de protección de tu autoría? Pero dice que por lo menos hasta ahorita, pero aunque sería muy importante explorarlo posteriormente, no hay, o sea, esta protección a la creatividad pues no es tan necesitada o no la ve tan a flor de piel dentro de los procesos creativos en específico de una obra teatral, ¿no? En cuanto a la pregunta de Laura sobre si incluso, por ejemplo, decía Laura, ¿no? Justo ahorita esta presentación tiene un guión, ¿no? Y conlleva un guión, algo que él preparó, podría ser sujeta de protección. Y bueno, dice Luke que en teoría sí, pero que al final de cuentas caemos como en esta cuestión de los ejemplos que nos dio acerca del teatro, de para qué alguien, si él viene aquí a compartir su conocimiento y bueno, que ya de alguna forma añadimos Laura Luna y su servidora, de alguna forma ya es un poco la colaboración de lo que él ha creado, digamos, pues para qué o cuál sería el punto, ¿no?, que él como creador demandara a la universidad por hacer difusión, ¿no?, si a él o a eso viene. Es también un poco diferente, justamente, ¿no?, el trabajo académico pues se hace para esto, ¿no?, para compartir conocimiento, para poder desarrollar más, etcétera, ¿no? Pero ciertamente pues ni siquiera nosotros como abogados nos ponemos aquí no veo, I don't see anything on your slides that says like copyright belongs to, you know, like you can use this for diffusion as long as you quote him, no, like you quote the author. No hay nada en sus slides que les prohíba a ustedes. Estuve viendo que varias personas toman fotos de ellas y Luke no le puso nada de, bueno, las pueden usar para no sé qué y no sé qué, y no se pueden usar para explotación comercial, ¿no? Nada los detendría ahora, pero no les estoy dando ideas, de reproducir su plática y cobrar por ella en algún otro escenario, ¿no? Estaría súper mal y no es lo que prevenimos, pero bueno, de alguna forma, pues, tampoco es algo que se cuida dentro del ámbito académico, precisamente por la razón de ser de la academia, que es compartir conocimiento. Quisiera darle la palabra al público por si quieren alguien hacer alguna pregunta. La pueden hacer perfectamente en español, se la traducimos a Luke. Sí, por favor, adelante.
Thank you, Luke. A comment about the Beijing Treaty, and also Heidi Lung was telling us that in Russia there is a huge movement from theater directors trying to protect the directing itself, not a play. And I mentioned the Beijing Treaty because it's on the interpretation of the actors, each interpretation. Aside, I'd like to know if in the UK, can you have copyright protection ex officio, or does it have to come through complaint? Meaning, should the state try to protect the creators because of the creation itself, and not translating all the costs to the person? You know, like the state should have the creations protected, and that wouldn't mean that the directors or the creators should spend so much money on demands. Thanks.
Thank you for your questions, very interesting. So the Beijing Treaty is kind of about performers' rights and the recordings of performers on stage, and that's a very important issue, and it's something that I'm definitely going to explore in the book. But it's not actually about the authorship of the work that is being performed, right? So that there is an interesting, and I've written a little bit about in the past in music, for example, which is similar to theater, in that the performer could be a different person to the composer. So the writer could be a different person to the actor. So there is this distinction in copyright, which is probably a little bit unfair, in that the writers and the composers, get all of the royalties, and then the performers have to rely on performers' rights. And unless you are broadcasting the specific performance that was recorded, then something like the Beijing Treaty on Audiovisual Performances will not be useful to you. You know, if somebody else performs the same work, and even if they kind of take influence from your performance, you're not going to be relying on performers' rights to take action. You're going to have to try to argue that they've almost taken a part of the arrangement or the adaptation, let's say, that you did as a performer. So it's an interesting question. At the moment, the way the law works is that performers' rights are separate to authors' rights. And authors' rights are more valuable because the author of the work of art, the dramatic work, the musical work, will get a royalty every time that is performed. But different performers only get the performers' rights for their performances as they're broadcast and recorded. So it definitely works to the disadvantage of performers, these kinds of rules. But it is absolutely fascinating. It could be that in some situations the line blurs between performer and author. And so perhaps we need to think a bit more about whether the, perhaps through something that, like, as Luna said, if you use something like Creative Commons to define a more collaborative way of acknowledging authorship, creativity, and so on, maybe you wouldn't have to have this very strong dichotomy between authors' rights and performers' rights. Maybe you could be more fair in the way you do it. But that is the way that we have it at the moment. But thank you for that point. I'm going to think a bit more about it, and I do appreciate it. In terms of the costs and the ex officio element of copyright, it's a very interesting point as to whether, should the state do more to, for example, at the moment in the UK, you do not qualify for any legal aid if you want to take a case on copyright, or actually really any kind of private litigation. You don't get any legal aid. You only get legal aid for, like, if you're criminal, if you're accused of a criminal offense or anything like that. So the state at the moment is not really encouraging or incentivizing these kinds of claims. So it could be the case that, and of course then the fact that they're very expensive is a massive disincentive to do it. So there's an argument perhaps that the state could do more. I haven't really heard about the Russian theatre directors, but I will definitely investigate that. So again, I thank you for that comment.
What about the work for hire agreements in the UK? Because it's a good way to concentrate the ownership, and if there's a difference between being the holder of the ownership, or to be owner of the copyright, or to be author, I suppose there's a strong difference, and obviously they work for hire agreements as a way to concentrate their authorship.
Thank you. It's a really interesting point, and it kind of brings up there's a strange divergence between, let's say, the way theatre works and the way the world of TV and film work. Right? The way that TV and film and this idea of kind of being commissioned as or being an employee or doing a work for hire, where all the kind of rights are vested in one entity, but everybody has a contract, let's say, with that company or that entity, and everyone knows where they stand. This is the way that films get made. This is the way that TV programs get made. It's extraordinary that if you go into a film studio or a TV studio and you ask these same questions, they have contracts for absolutely everything. If you rewrite a script, you get a credit. If you came up with the idea, for example, you might see in a film credit, story by Anna, written by Luke, with work by Laura. They have all of these ways of defining, and each of these people will have a contract with the entity, and when you speak to people who work with both film and TV, and then also with theatre, they say it's incredible the difference between these two creative environments. And they say that I met one lawyer, a New York lawyer, who said that it's partially to do with film and TV are much more commercial entities. You know, there's much more money to be made, so everybody has to have these contracts in place, because if you have a TV show or a film that becomes so successful, and there's a lot of money as well that it takes to make these things. You know, theatre, once you have the space, is not that, and once you have maybe even some sets can be very basic. It's not so expensive to produce, but you know, a film show or a film or a TV show, the amount of money that's involved is often far higher, and so they have to make sure that everyone knows who will get the money if it is successful, right? But it's fascinating because they're both creative, they're both writing scripts, they both involve actors, they both involve directors, and yet they're like two different worlds. So there's certainly a lot more that I can do to explore that, and I'm, you know, as I said, I'm kind of at the, I don't know what stage I'm at in terms of writing the book. I hope I'm about, I'm probably not even halfway there yet, but I'm very interested by that question. At the same time, my impression from doing the interviews with the people in theatre is that there is something about theatre that is different. You know, there's some sort of magic that is there in the realm of theatre where you're not thinking about contracts and you're just giving of yourself to it. You know? So I need to find a way of really describing that and making it, and you know, the comparison with film and TV is a really useful one. So as I say, thank you, and you know, I'm going to keep working on that.
Buenas noches. Se mencionó un caso del Tribunal Europeo de Derechos Humanos, me parece que es Norwegian versus Arcs Limited, y en el que mencionamos que el tribunal se pronunció sobre si una película podía considerarse una obra dramática. Me gustaría saber en qué contexto el Tribunal Europeo de Derechos Humanos se pronunció al respecto.
I think it was the European Court of Justice case. She's asking like if the question was whether the movie was a theater, like a dramatic work, and what was the context of it.
Sure. It's a great case, actually. It's a UK Court of Appeal case. It's Norwegian and Arcs.
So it comes from the European.
No, it's just a UK case. It didn't
go to the IIJ.
No.
Oh, okay.
So what happened in this case is that this is really an insight into sometimes how things like advertising work, right? So this case was a dispute between a filmmaker and the advertising agency who did a very famous ad for Guinness, for the Irish beer stout company, right? So
the only beer.
So here what happened was this advertising agency put out a call where they said, we've been engaged by Guinness to do a new ad, we want to do something new and sexy and exciting. And so that they had kind of auditions almost for filmmakers. So filmmakers came in and they showed their films, and then they were potentially going to be picked to be the filmmaker for this Guinness ad. And the advertising company ended up not taking this particular filmmaker's ad, Norwegian. But when the eventual ad came out, like with these other cases, he said, hold on, that's very similar to my ad. And what he had come up with was, basically it was a man dancing, but he was using this technique which was quite novel at the time in the 90s called jump cut techniques. So for example, the first scene would be the man dancing next to the camera, and then it would jump cut, and the man would be dancing right way in the back of the room. And then suddenly he'd be dancing in the center. So by using film edits, this man was going to be all over the place. It was a very entertaining clip to look at. And the eventual ad, which is on YouTube if you want to look it up, is of a man dancing to a kind of fiesta music, actually. It's kind of da-da-da-da sort of music, and the guy's dancing all over the place. And at the end, and the trick of it is that if you pour a pint of Guinness, you can't drink it right away. You have to wait 30 seconds for it to settle. Right?
Mhm.
And so this guy's dancing while his pint of Guinness is settling, and then at the end he picks it up and takes a drink, right? So it's entertaining you while you wait for your Guinness to settle. So anyway, this filmmaker, he really felt aggrieved that he said, you know, they didn't pick me,
But then they used my idea.
but they used my techniques, my ideas, so I'm going to sue them. And so the first case he took, so for example, you can see it's Rosen versus Arx number 2. So in the first case, he said, you infringed my film. And the company was able to rebut that very easily because they said, no, we made our own film. Not a single frame of your film is in our film. So how can you say we stole your film? And the court said, under copyright law, that's correct. Unless you take the literal pieces of film or a clip and put it in your own film, you're not infringing the film. What you could argue, and what you had to argue in the second case, is that, so for example, if you reenact a scene, if you reenact the Hasta la Vista baby scene from Terminator, you're not actually infringing the film itself, but the script. You're reenacting the script of the film, right? So here, he couldn't argue they'd stolen his film because they had actually created their own film using similar techniques. So he had to argue that the film itself, his original one with the jump cutting techniques, was a kind of scripted work itself. That it actually had enough, that it was a dramatic work, not just a film. And so the court there was willing to accept that a film could be a dramatic work. A film could have elements that involve a script that could be taken by someone else. Though unfortunately for him, they still said in this case, all they've done, like with, for example, the Da Vinci Code case, in that case they took a historical theme. In this case, they took a technique of editing. And they said, you cannot have a copyright on this. Copyright is not patent law. You might have, even if you invented this technique, that's not what copyright protects. Copyright protects works, and a technique is not a work, therefore it's not infringement. So that's the context.
Bueno, voy a traducir porque me parece súper interesante. Sobre este caso, bueno, se había contratado a esta compañía para hacer un anuncio de la cerveza Guinness y al final no se contrató a la compañía, sino que, bueno, se contrató a alguien más, pero el anuncio terminó siendo la utilización de la técnica de edición. Nos explicaba Luke, bueno, la técnica de edición consistía en tener cortes de una persona bailando en un lugar, luego en otro lugar, de tal forma que se veía que estaba en todos los lugares. Y esta técnica de edición fue utilizada para el comercial final. Entonces, la persona que originalmente había hecho este trabajo es la que demanda a la empresa, sí, que terminó haciendo el anuncio de la Guinness, y al final lo que dice la Corte es, a ver, el derecho de autor está hecho para proteger una obra creativa, no para proteger una técnica de edición, ¿no? No es, eso lo podrías llegar a hacer quizás con derecho de patentes, proteger la edición, una técnica de edición de filmación, pero el derecho de autor no sirve para este caso. Entonces, bueno, y también se probó que no fue usado nada del video original, no fue copiado en el video final, entonces, por tanto, pues no había una violación, una infracción a derechos de autor. And I was just wondering that this other case that is actually, maybe this is what she saw, the Human Rights the European Court of Human Rights, this one.
I think that's something else. That's something like that's not ECA. That's not European Court of Human Rights. That's something to do with it's the law report that it was reported in. So it's
So no significa la Corte Europea de Derechos Humanos, sino que es nada más el lugar en donde se reportó este caso. Okay. Bueno, así, ¿alguien más tiene alguna pregunta para terminar? Si no, sí, por favor.
No sé si quepa.
Sí, claro que sí. Así,
desde luego, a mi poco inglés, la exposición de Luke es brillantísima. Esto, desde luego, debo entender que es la legislación de United Kingdom. ¿Sí?
Sí.
A la mesa le pregunto yo, dentro del aspecto de derecho comparado, ¿cómo andaríamos nosotros en esta brillante exposición? Porque un caso concreto que he estado escuchando en la radio respecto de la personalidad de uno de nuestros artistas más populares de las últimas fechas, el señor Aguilar, conocido como Juan Gabriel. He escuchado que va a haber una especie de pesquisas indagatorias a todo aquel que quiera imitar los desplantes, las canciones, la actuación en público.
So we have a very famous Mexican singer that a few years, like just 2 years ago, passed away, sadly. But he was, I mean, he's not only famous because his songs are super famous, and there were a lot of performers singing his songs. Like he's like an author of probably more than 100 songs. But also he's very famous for his performances, live performances. He has a special style of dancing, ¿no? Tiene un estilo muy especial de bailar, tenía. He says that there's going to be like a case where they are going to look for the people that is imitating him. But you know, Mexico is the land of imitation, sadly. And I don't know, I would say like we are not big into the knowledge of acknowledging that something is imitating, and that we are actually that we are full of plagiarism as well, sadly, you know. But he was actually asking us what do we think in regards to what has been developed in the UK towards or head to head to what we already have in Mexico. So this is this would be my first comment. Like, you want to say something before we?
Yeah, I mean, certainly that there's something called image rights, which is not copyright, but is closer to kind of trademark and that sort of thing.
Sí.
And there have been, I mean, it's not that well developed in the UK, to be honest, but in the UK it would be seen as passing off, and in the US it is kind of image rights. But there have been some cases. So, for example, I think both Bette Midler and Tom Waits have won cases in the US where advertisers used sound-alike people to do songs on ads. So people watching would think, oh, Tom Waits is advertising Coke or whatever. And so Tom Waits sued the advertising company because even though they hadn't copied his songs, they only copied his style of singing, which is very distinctive. Mm-hmm. And he won the case. So recently in the UK there was a case where the singer Rihanna, they used her image on a T-shirt without her permission, and they said that was also a violation of because essentially they said it was they had passed off their T-shirt as if it was in contract with Rihanna, which they said was basically a fraud. So you can have some things that are within intellectual property law that could protect, like this performer, if his performing style was so distinctive, if other people are copying him. But interestingly, it's not copyright law that does that. It's these other elements of law.
No sé si Luna y Laura quieren comentar algo de lo que nos pregunta el señor y luego ya cerramos. ¿Quieres?
Pues el marco normativo mexicano por el momento es muy restrictivo en este sentido, y si impera justamente el imperio del copyright, todavía tenemos jurisprudencia de la Suprema Corte de la Novena Época que habla de estas cuestiones. Son muy pocos los casos que han llegado al Tribunal Constitucional, y la ley tal y como está, la Ley de Derechos de Autor, en el artículo 83, tal y como está redactada en este momento, no nos permitiría el acceso a estas licencias Creative Commons o más libres de las que hablaba. Entonces sí tenemos un panorama muy restrictivo en este sentido, y con
restrictivo pero tampoco proteccionista, o sea, como
Ajá, exacto, restrictivo y no proteccionista para los autores, sobre todo más bien muy proteccionista para dentro del tema de los derechos conexos, y que serían todos estos derechos patrimoniales de todos aquellos que no son los autores directos de la obra y que pues discográfica y que están en medio del autor y el público en general, ¿no? Este es un poco el panorama en México, por eso pienso que es muy importante empezar a reflexionar en torno a otras alternativas dentro de este tema.
Brevemente, nada más coincido con Luna y otro ejemplo que tenemos aquí en México, another example that we have in the same type of Rihanna t-shirt, con la serie de Luis Miguel, with a Netflix, famous singer.
You don't know him.
Empezaron a comercializar playeras con la imagen del actor que hace el papá de Luis Miguel, ¿no? Y el mismo actor dijo, bueno, no, yo no consentí para que utilizaran mi imagen en este tipo de playeras y ya existe pues todo un mercado para que está obteniendo ganancias, etcétera. There are whole t-shirts with the actor,
The father of the play, but
the main
it's the
actors.
actor, not the.
But it's the actor. So and he says, well, I didn't consent for them to use my image in the t-shirts.
Sí, y bueno, yo lo siento, yo creo que sí que nos podemos ver al ratito para platicar, pero bueno, ya nada más para terminar, porque ya estamos sobre la hora, pues precisamente es la idea de nuestro seminario de traer este tipo de pláticas y charlas a la discusión del público, justamente, bueno, por un lado, para hacer más conciencia ¿sí lo dije bien? Conciencia sobre la protección que se está llevando a cabo dentro de nuestro país. Sabemos, y ya lo estuvimos discutiendo hace 2 semanas en nuestro evento del TEMEC, que nuestro derecho mexicano ha sufrido mucha influencia por los tratados internacionales que ha tenido que firmar, y que tal vez no necesariamente están siendo proteccionistas o viendo cuál es la realidad en nuestro país para proteger a los creadores de nuestro país, sino que más bien estamos adaptando nuestras leyes para proteger a los creadores de otros países y que no se hagan copias o no se infrinja su trabajo dentro de nuestro territorio. Que de todas formas, como ustedes saben, como todos mexicanos, hay piratería en nuestro país hasta por los codos, pero esa es la idea, o eso es en donde está tendiendo la ley, como dice también Luna, a tratar de asimilar la ley a lo que están pidiendo los tratados, la que están pidiendo países extranjeros, de que nosotros tenemos que adaptar, pero no necesariamente buscando cuáles son las necesidades de los creadores mexicanos, ¿no? Entonces, yo creo que eso es algo que nos hace falta poner a la mesa en discusión. Y pues por lo menos sabiendo de otros casos y viendo cómo se protegen en otros países, quizás podamos seguir aprendiendo. Un último comentario es, bueno, en cuanto a por qué también en nuestro país no se llevan a cabo acciones. Bueno, en primer lugar, porque por falta de conocimiento de cómo se deben llevar acciones. Y bueno, incluso en una ocasión que estuvo con nosotros Eduardo de la Parra, que a lo mejor ustedes lo conocen bien, pero bueno, es un gran abogado de derechos de autor en nuestro país y que ha llevado muchos casos de derecho de imagen y de derecho de autor en general. Él nos comentaba que vino la familia… Ay, me voy a matar, pero bueno, no me acuerdo. La familia de un cantante mexicano que ya falleció, no quiero darles un dato falso, a verlo para ver qué podían hacer sobre las obras que se estaban infringiendo de él. Y pues él les explicó todo el caso que podían hacer, etcétera, pero al final de cuentas la familia no quiso demandar, no quiso ni siquiera iniciar la acción ni buscar por algunas muy similares razones de lo que nos ha comentado Luke hoy, ¿no? Por miedo a perder y tener que pagar los costos y por no querer privar de la creatividad que se pudiera generar con estas obras. Pero bueno, hasta ahí la dejamos por ahora. Les damos las gracias por haber atendido todo este semestre a nuestro seminario. Los esperamos de nueva cuenta en enero para las nuevas sesiones. Bueno, y no me despido sin antes dar las gracias al doctor Manuel Becerra, que no pudo estar con nosotros este semestre porque está de año sabático. Bueno, el doctor Pérez Miranda, la maestra Carmen Arteaga y a nuestras colegas que nos han hecho favor de suplirlos de una forma excepcional el día de hoy, a Luna y a Laura, y por supuesto a nuestro invitado de honor, el doctor Luke McDonough. Muchas gracias.